Good evening, everyone. Thank you for joining us for the second session of Sports Law 101. Sports Law 101 is an initiative of the Sports Law and Policy Center, where experts from the field cover contemporary issues on sports law and policy through monthly discussions. Today's topic is on decoding anti-doping violations. I'd like to introduce to you our speakers for this session, Mr. Anish Dayal, Counsel, Supreme Court of India and Delhi High Court, and Mr. Suheil Tandon, Director Founder at Pro Sport Development. I'd like to hand over to Suheil to take forward this discussion. Over to you, Suheil.
Thank you so much, Vani. Yeah, it's good to be here. And I think today we are touching upon a very important and quite a relevant topic in today's sporting context in India. So, and I'm very glad to be alongside Anish, who's had a lot of experience in this field. So what I'm going to do is I'm just going to set the scene. Why are we talking about anti-doping? Today, what relevance does it have to sport? So I think doping has become a big issue, especially in India, given our push to do well in sports globally over the last decade or so. And the numbers, will speak for themselves. So in 2019, India's doping violations more than doubled its own tally. So in 2019, the doping violations stood at 187, whereas in 2018, they were just 74. In 2019, India was ranked 7th in the world when it came to committing doping violations. That's the wrong reasons to be in a top 10, to be honest. Many of you might have heard that India's National Dope Testing Laboratory, or the NDTL, was suspended by WADA, which is the World Anti-Doping Agency, for 6 months in 2019. And this was extended, the suspension was extended in 2020. These numbers don't really bode well, for a nation trying to compete with the best in sport globally. Today, what we've done is we're going to divide the session into almost the 3 stages of anti-doping in sport. Even before anything, how can we prevent athletes from doping? So prevention is going to be the first aspect we look at. Moving on, we'll also look at then the testing procedures. When do athletes need to be tested? What are the testing procedures in relation to that? And lastly, we'll come to the disciplinary procedures. So if there is a positive case, if there's a doping violation that has been committed, then what are the procedures? I think at this point, it's important for me to say that, especially having briefly discussed with Anish before, we just want to put out there that, there is zero tolerance for doping in sport. I think it's very important to uphold the values of fair play, clean sport, and trust. And this is not just pertaining to the athletes, but all the support personnel, including coaches, managers, etc. And also for the fans. I think, the sporting fraternity owes it to the fans to keep sport clean. Having said that, I think we need to really move. So I've given you some numbers, but I think we need to move beyond those numbers. I think the state of doping in India, there are several socioeconomic factors that lead athletes in India at being at greater risk of committing doping violations. I've seen this firsthand working at the grassroots. And the major factors include, lack of awareness and education on anti-doping. And again, that's not just the athletes, but the support personnel associated with athletes. Also, there's a lot of misguidance and misinformation that is circulated within the sporting fraternity. Finally, there's pressure to perform. Because for many, sport is a way out. Sport is a way to a better life. And there's pressure from coaches, parents, families, and peers. so that pressure leads to athletes committing doping violations. And also, in India, if you see, as in our education context, even in sports, athletes and support personnel, especially coaches, they share a guru shishya relationship, whereas it's very hard for an athlete to question coaches and to understand why they're doing what they're doing in terms of training, in terms of all aspects of sport. So I think it becomes very hard for athletes and even sometimes support staff to challenge the status quo. And I mean, one example is working in the grassroots, when I saw firsthand 15-year-olds at a district sports competition taking syringes and committing doping violations even without knowing it. This is the under 16 competition at a district level. That's when it hit me that it's a problem. It's a deep-seated problem. So all the numbers you get are for more national level athletes. So I think that's a big issue. So I'm just going to stop there. And Anish, I'd like you to come in and share some of your perspectives, but also share some of your insights into how can we prevent athletes from doping, and what are the preventative measures that we can take.
Thank you, Suheil. Thank you, Vani, for kickstarting this. So taking a cue from what Suheil was talking about, saying no for an athlete is very critical. And doping is a complete no-no. When we talk about anti-doping, I think what we are talking about is a certain section of athletes to how to support that set of athletes which are inadvertently caught in doping. But if you have cheated in the first place, knowingly and intentionally cheated, there's really no reprieve for you. And ideally, there shouldn't be. And the reason for that is that the basis of sport is clean and fair competition. I think we have all grown up on that basis. We don't need to read a legal book for that. So the spirit of sport needs to be respected in all its expanse. And that spirit requires that you should not cheat. Now, what is, as various stakeholders in an athlete's life, see, the core of sport is an athlete. So let us use that as a fulcrum. That's why we keep talking about the athlete. Now, there's an ecosystem around the athlete. There is a coach, there's a support system, there is a federation, there's a team owner if it's a private league. There is, at the highest levels, there are regulatory authorities and the disciplinary authorities. So all of us, including, let's say, lawyers who end up defending athletes or are prosecuting on behalf of NADA, should have a stake in stopping doping. Now, how do we do that is the point. So we go back to the old adage of prevention is better than cure. And let's talk a little bit about that. See, when we get to interact with an athlete as a lawyer, it's only at the stage when an athlete has received a notification saying there's a positive substance. And then they come to a lawyer saying that, well, tell us what to do now. At that stage, what has happened is that we have, over various years, used a process to actually talk to the athlete, try and figure out what were the circumstances in which the athlete has been found to be having a prohibited substance in his or her body. In that process, we have come to know, or at least be aware, unlike Suheil, we are not on the grassroots. So I'm giving you a very different perspective, saying that, well, we really didn't know what has happened and I have no idea. So there are two sets of athletes. One is person who doesn't know how the substance came into the body, and a person who can sort of trace that how the substance came into the body, but did not take it intentionally. And third, situations where you could have been, there could be a conspiracy against you and all that, but that's very rare. Now, now these athletes keep saying that, listen, we have no idea. So I asked them, have you had any awareness campaigns? Have you been part of any awareness camps? Some say yes, some say no. I mean, there was a time when I was horrified when I was addressing a room full of Paralympians. And I asked how many of you have been part of a training camp? And about just a couple of hands went up. And so this was a bit shocking. Now, I am sure the regulatory authorities like NADA are doing the job to the best of their abilities with their resource crunches. But the point is that we need to step up more. And this has to happen at every stakeholder level. So, as I said again, who are the stakeholders? Federations, team owners in private leagues, NADA, of course, and support personnel. Now, at each level, if we raise the awareness of the athlete by trying to tell them as to what is anti-doping, what is actually prohibited, what is the process that you need to employ, if somebody is forcing you, what do you need to do? So that, I think, is an important task. The different social economic criteria plays a huge role in getting an athlete trapped into the situation. Now, we receive athletes from all kinds of backgrounds, all kinds of language issues, all kinds of people who don't speak English or Hindi, and are often accompanied with a friend who's an interpreter, stroke athlete friend, and who does the interfacing job. Now, to expect them to know the rules and to expect them to know that, listen, for example, they took a cough syrup and they ought to know technically what was in the cough syrup is a bit tough. Although the reality of anti-doping is that you should know what you're ingesting. So do understand that as per Article 2.1 to 2.9 of the NADA code, presence of a substance is not the only offense. You also have issues of tampering, avoidance, trafficking, relating all violations relating to the anti-doping system. Now, so therefore, if you are accused of any of these aspects, you can come in with the anti-doping issue. Now, the thing is that have the athletes been told that there are these 10 possible violations? Even if you abet somebody doping, suppose you know of somebody is doping, are you conspiring? So that whole ecosystem has to be buttressed, according to me, a lot more. Now, language and awareness is very critical. We have really, and that's something I'd like to say, that, everything in the ecosystem is around in English mostly, right? Sometimes we have worked hard to create handbooks for athletes in English and then Hindi and whatever. So there, it's important for us to focus on that part. The other thing is the guru-shishya relationship, as Suheil rightly mentioned. The subservience of the athlete to somebody coaching them or to the federation. And the problem is, once the athlete is found to have a positive thing, the athlete becomes like a pariah. Federation doesn't touch the athlete. Nobody touches the athlete. And then finally, God willing, if he gets some legal help and the right legal help, he or she can be guided in the process. So I think that's one thing. The other important thing which comes up is issues of supplements. Now, for an athlete who has not cheated intentionally, the substance must be in the athlete's body through either a contaminated supplement or a supplement which the athlete took inadvertently, not knowing what the ingredients are. Now, there's a huge problem in standardization of supplements. We have no real system to say that, well, this supplement is correct and this supplement is not. Although there was the collaboration with the FSSAI at some point of time, and I believe, I'm not sure how is that operationally being done, to say that, well, this is a standardized supplement. But I still think the best minds should work together to figure out what is the way to say that, listen, this is a proper supplement. One of the suggestions which came up in an international conference once was to, if you can't have a positive list because you don't want to endorse a particular brand, you can have a negative list. A negative list would mean that these supplements of these brands are known to be contaminated, or not even contaminated, or known to have ingredients which lead to doping. So that could apply to medicines and to supplements which are known in the sports ecosystem. So at least that would help a great deal in telling the athlete that, listen, don't take this. Or if somebody is advising you, can check on the website and don't take this. I think that's an important way to sort of do that. And I'll hand it over back to Suheil to say that, in terms of this whole interaction with the athlete, in trying to make them aware I don't know at the grassroots level what happens, but my experience when interviewing the athlete when they come for legal defense is that most of them seem to throw up their hands. I'm quite suspect that some of them are doing it because even if they have been part of a campaign camp, they probably are still, not saying the right thing. But even if I average out the response from the athletes, the sense you get, it's not enough. So you got to pinch it at the start. To keep punishing athletes, of course, that's a penalty situation. But if you spend a lot of time and energy, and I don't know if it can happen in the private space, I don't know if it can happen in the foundational space which Suheil is part of, and I'll just give it back to Suheil to say a few more words on that.
Thanks, Anish. I think completely agree with you. I mean, having seen athletes at the grassroots, I think they get zero to very less. They have zero to very less information on doping procedures, how they can commit an offense. And I think many of them, the first time they will know of this is if they test positive. But then, they're already at a stage where they are at a national level competition, but this has been happening probably, through the age groups, through the levels coming up. So I think there's a need for education. I think federations are well placed as well, but I think they need support from, like you said, the foundational space, the private space, because it's going to take a combined effort. And I think you hit a great point in terms of language. Language for many of our athletes now coming from, a tier 2, tier 3 cities, rural areas, they neither speak English, and Hindi is probably their second or third language. So it becomes very hard for them to, even if you do a workshop in English, those who don't speak English or not well versed will probably come away not learning much from it. So I think, doing the education awareness aspects needs to be done in local vernacular languages. And I think supplements, you hit the nail, in the head there. Supplements are a big cause of concern. And I think going beyond supplements, better information about nutrition is very important. I have seen many athletes who, obviously they are in a space where a high quality, high protein diet is not always very easy or very cheap for them to, make do with. So, the first leaning is towards the supplement. These are 14-year-olds, whereas they don't understand that supplements are actually, they are supposed to supplement your dietary intake. So I think even that, nutrition has a big role to play in there.
Suheil, I would like to say the word supplement throws up such a negative reaction to whoever is, maybe when we have argued matters in NADA, and which is surprising because everybody knows that you would be supplementing your diet by something. Yes, but that something becomes an issue.
Yeah.
And particularly the 14 to 15-year-old, Suheil, I would like to say, in fact, one suggestion and some initiative was happening that why can't you have comprehensive apps on the mobile, where an athlete who's carrying a mobile nowadays actually presses, and I hope somebody can take that initiative, and actually has all the relevant information, at your fingertip. I mean, I'm throwing this suggestion out. I know some initiatives have happened and I hope they fructify. But how easy is that? I don't see why we don't concentrate on just creating that platform where so many athletes of our country can go to and understand what is the basic, what we are talking right now in this 1 hour.
Exactly.
Much more organized format. You get it on an app. You also get the prohibited list. You understand what is it, and get on with it, rather than being open to the whole World Wide Web and not knowing where to go.
Yeah.
Talking that suggestion to whoever is listening, and hopefully somebody can work this out.
Definitely, that's a great suggestion, and I think we have the know-how. I think I think it can be put together, and it's just getting athletes to access that information easily.
And particularly the 14, 15-year-olds, it's really
exactly
stories about syringes, and it's really painful. that even an urban 14, 15-year-old who's competing is not aware. I can understand that a rural or a semi-rural person coming from semi-rural with a language problem is not aware. Yeah. And we understand, Suheil, as you rightly also said, that sports and achievement is an escape out of a socioeconomic condition, mostly.
Yeah.
I mean, our best athletes come from the poorest backgrounds.
Yeah.
There have been painful stories which, we don't have enough time. But I think that's important to understand. I keep insisting, and I'm insisting again, it's really important to understand the basis and the framework of our Indian system. We have a Western law. I would say Western only because it's an international system, and sports legal framework works in an international system.
Yeah.
Like a pyramid. Now the thing is, but we have the intelligence enough, innovation enough in India to adapt ourselves, to cater for our own cultural situation, is my point.
I think context is very important, especially when you come to the grassroots, and that context might change from even state to state in India. So I think that's very important, and I mean that's a very pertinent point. So I think let's move on. I think I'll come back to some of the things you mentioned about, like what are the 10 different ways that, because that's something not many of us are aware of. And syringes seems to be, you mentioned it, I've seen it in my own experience. Syringes seems to be a very common and a very distressing part of this whole doping ecosystem in India. Just before I move ahead, please, if you have any questions, do put them in the comment section. We'll aim to answer that at the end. There'll also be some time to maybe ask a couple of live questions. But in case you have questions, just keep putting them in the chat. So moving ahead, Anish, I think this is a good, base for, how can we prevent doping? But there is already a procedure, there's already a system in place to test athletes, which is also important to ensure, fair sport, clean sport. So I'd just like to start with, what are the types of testing that athletes have to go through? And what are the athletes' obligations when it comes to these testings?
Okay, so this comes into my territory of trying to decode the NADA, National Anti-Doping Rules, to you. So very quickly, since this is not a class in that sense, but so the whole anti-doping regime internationally is governed by WADA, World Anti-Doping Agency. And they have what is called the prohibited list, which they update every year. The prohibited list has largely two separate, the categorization is as follows. There are certain substances which are prohibited in competition, and there are certain substances which are prohibited out of competition. Then again, the substances are divided into two categories, and this is very critical. You have specified substances and you have non-specified substances. Specified substances are the ones which are generally the athlete may be expected to have in their daily usage, but are still prohibited. For example, you have terbutaline in cough syrups. We have had a lot of cases in India on terbutaline. So, or the milder ones, like you can have salbutamol, for example, which you use for asthma. So that's specified, which carry a lesser sanction at the end of the day. And the non-specified substances are the serious ones, like, you have steroids, anabolic steroids and stuff. So that's how the list is largely classified. It's, of course, I'm not going into detail. Now, everything moves on the basis of that list. For each country, there's something called the National Anti-Doping Organization. That's called NADO. Our India's NADO is NADA, is National Anti-Doping Authority. Now, NADA is basically responsible for testing. And the testing actually happens through a laboratory called the NDTL, National Doping Research. Now, as you mentioned, unfortunately, the NDTL of our country has been under suspension by WADA. And I believe the suspension is still on. I'm not sure. There was a 6-month suspension which was supposed to finish in January. Now, because there were some procedures which were not being followed. So that's an internal regulatory process which WADA is going through. Now, So when NADA actually sends out a doping control officer, which is called a DCO, to test, it could be in various situations. It could be that after your podium finish, you could be approached and you could be tested immediately after that, which is quite a high possibility. Secondly, you could be tested out of competition because you might be as part of a list, a registered testing pool. It's called a registered testing pool. You might be part of a list, or certain circumstances and history of the athlete, which there's a process where NADA would understand that this athlete needs to be tested. Okay, or maybe before a big competition like the Olympics or something. Now, when an athlete is approached by the DCO, there's a chaperone, and you're supposed to give your urine sample. Now, the urine sample needs to be given in certain conditions. The test kit should be sealed. Typically, the athlete is supposed to open the seal and decant urine in that. Now, there are lots of issues, and then the athlete is supposed to get it sealed in front of them. Now, this whole process is a very delicate process, which must be ensured, and athletes need to know what exactly are the rights at that point of time. Typically, the DCO ought to inform the athlete of what their rights are at that point of time. Now, that interface or that right information of rights sometimes happens, sometimes doesn't happen, right? Because typically what happens, it becomes a bit more casual. That's what athletes tell us. I don't know, but athletes tell it becomes casual. The DCO comes and says, "Arey, sample de dijiye aap aur kya hai, farak nahi padta." So I think there's some importance to adopt a more proper process at that stage. Secondly, to tell the athlete as to what is it, how important it is for the athlete to see that the kit is not broken, tampered with, and that he or she is giving a urine sample, a clean urine sample, and which is actually put in two bottles called the A sample and the B sample. There have been issues and cases that we have dealt with where the athlete has been unable to decant enough. There's a certain amount that they need to take, and it's called a partial sample collection. In a partial sample collection, there's supposed to be a partial kit, which is supposed to be there, which sometimes is not available with the DCO. So there have been cases where the partial kit was not available, and the athlete didn't really know what to do, because the partial kit also has to have a process, because you take some part of the urine and then it has to be put in a situation where it's not tampered with and then sealed later when the full sample is collected. So the whole process had to be very tightly supervised. The other part of the process is, aside from the sealing, is the filling of what is called the doping control form, the DCF. Now here I'll just spend a little more time because this is very critical. The DCF is really a format in which the details of the athletes are noted down, and the details of the DCO is noted down, and the witnesses is noted down. And there is a little box at the bottom, which is a focus of a lot of our arguments in court, where the athlete is asked, "Are you taking anything? Is there a medicine you're taking or a supplement you're taking?" Now, as part of this conversation between the DCO and the athlete, what is recorded is sometimes strange. Sometimes it's written like proteins. It's the generic name. It's written like medicines. And this is where the education and awareness problem comes in, right? क्योंकि वो बात होती है आपस में, and then they say, "अरे यही लिख दीजिए आप," or the athlete doesn't know how to write in English, so they tell the DCO कि भाई आप लिख दीजिए, you write on my behalf. Now this is a very critical phase, because what you disclose in that box is your defense ultimately in the matter when it is heard as to the source of the possible substance which has come into your prohibited substance which is in your body. So let me just quickly say, the liability arises from a presence of a prohibited substance in the athlete's body. That's principle number one. Principle number two is the athlete is responsible for what is in the body. That's part of the principle. And then third, the athlete has in its defense, as a starting of its defense, to show as to where did that substance come from. And fourth is, once you show where that substance has come from, then you say, "I took it negligently, inadvertently, there was no fault." This is the basic process. So when we asked the athlete what happened then, why didn't you say that this particular substance you were taking or a cough syrup you were taking, why didn't you write that? Why didn't you write the brand? Well, they said, we didn't really know about it and we just wrote and all that. Okay. So that's very important point, that it must be recorded properly. And I believe our DCOs or whatever should be trained enough to actually assist the athlete. This is not a, if there's full disclosure, it helps everybody. It helps the prosecutor, it helps the defense, both. It could be either. The other thing is that if you have a problem in the way the DCF is being filled by the DCO, then what do? Because he'll say, sign kar dijiye aap. Usme niche, there's a signature which says that I've read and understood the contents of what is above and I'm signing it. That line has been used against an athlete to say, well, you signed it, so you know exactly what was there. But you see, it doesn't happen. In reality, it doesn't work like that, right? So we have suggested sometimes to athletes and awareness campaigns that, listen, if you have a problem, why don't you write an email? First, why don't you write on the DCF that, listen, what I said has not been filled up. Now, that's an ideal situation. The DCO may not allow you to do that. But you can write an email immediately thereafter to the federation, to your parent federation, to say, well, I was tested. I told something, but this was not recorded. Okay, so at least that helps in full disclosure. Number one, full disclosure always helps an athlete who's not cheating. We are talking only about athletes who are not cheating. If the athletes are cheating, that's a different story altogether. But we're talking about athletes who are not cheating. So that process of full disclosure always helps. So so that I think is an email or something is very critical. The other two things which one can note, whoever is interested in understanding the framework, is there are two duties on the athletes separate from that. One is to fill whereabouts forms. There's a concept of whereabouts. If you're in the National Registered Testing Pool, you're supposed to inform NADA on a software where you're going to be. And there have been lots of controversies relating to whereabouts in cricket, this, that, and the other, which you can read about. So that's a failure to fill the whereabouts form also leads to a sanction. We've had during COVID, we've had situations where the athlete says, like, listen, I was clearly at home. What do I tell about whereabouts? I said, but you still have to fill up the form. So you see, the intent is okay, but there's a laxity in the process and compliance. Because some athletes don't know, they're interested, they're sports people, for God's sake. They are not supposed to be, they're not, no exact compliances. But if they're made aware, then they'll comply. The second thing is getting, and this is another important thing, is getting a TUE. Now, a therapeutic use exemption. Now, for all the substances which have a source in a medicine, in a pharmaceutical product, you will only get off if you had that medicine under an exemption applied prior to having that medicine, which is called a TUE. Now, sometimes athletes say, listen, I had a cough. I went to the pharmacy, and in India, you get everything off the shelf. So I asked him for a cough syrup. Pharmacist gave me the cough syrup. How do I know? Nobody reads the ingredients. Even if you read the ingredients, you'll never know what is prohibited and what is not. After many years, I came to know that terbutaline, which is an expectorant, bronchodilator, is actually prohibited. It's in most cough syrups and a lot of cough syrups. Now, the thing is that how do you figure that out? How does the athlete figure that out? So some suggestions I have earlier given is that the athlete, ensures full disclosure. You have taken a medicine off the shelf. Please write an email to your doctor, to your physiotherapist, to your federation saying that I have taken this. I hope it's okay. Now, assuming that it's okay, you'll be fine. But at least you have disclosed. You're not cheated. You're not cheating. The problem is if you don't disclose, that means you're cheating. Please, and that's a very critical point in a legal analysis. Lack of disclosure, there's a presumption that you have hidden something. So ensure disclosure. There are also lists like the globaldro.com where you can go and check that out. And the other thing I wanted to say that when you go to a doctor asking for a prescription, right? You, a sports person, must tell the doctor that I'm a sports person. Hopefully have it recorded on the prescription that you're a sports person. And ask the doctor if that doctor, it could be a doctor in the village. Unfortunately, we athletes are from rural areas and they go to the village's doctor or a government doctor or whatever, and they don't know about sports, sophisticated sports issues. So get that recorded maybe, and then the doctor will end up prescribing you something as per their medical knowledge, right? You can check hopefully on global DRO, but it's very difficult. It's all pharmaceutical agents list and all that. I mean, even lay people can't really understand. And then when back it up by an email saying that, listen, this is what the doctor is giving me, I'm reporting to you. Send an email to somebody so that, you are, so these are very rough measures, which I think for an athlete who does not intend to cheat, but is caught up in this lack of process, can do in order to help him or herself in the process. So that's the point I would say for athletes on testing, they should take care about. Hand it over to you, Suheil.
Excellent. Thanks. I think that's very interesting. And I mean, I've gone through a lot of anti-doping procedures and information, but how you put it, it actually combines the theoretical and the practical, because that's very important. What happens in practice is usually not what told to us in theory. And I think, again, comes back to lack of information that athletes receive, but also a point that you have brought up is about disclosure, about being transparent in terms of, anything that you've taken. Very interesting. You also mentioned that not filling a whereabouts form can lead to another doping violation. So if just briefly you can, so obviously what you've been talking about is, the most common doping violation of having a banned substance found in your body. But what are the other doping violations, and who other than athletes who can commit these doping violations?
So if you look at Article 2.1 to 2.9 of the NADA list, and people can do it offline, there are issues of presence, tampering, trafficking, avoidance, interfering in the doping control process, conspiring. All these are violations in their own right. And there are circumstances which are mentioned for each violation as to how it works. Now, technically, a coach or a support personnel who might be involved in the process can also be held up. But mind you, we haven't had many instances of that happening. So, I at least in my experience for couple of decades and all, I haven't had a situation where a coach is actually held up for, a situation saying that, oh, actually I prescribed it and therefore I'm responsible, or the NADA goes after the coach. Now that could be due to lots of, underlying reasons and, hierarchies and stuff like that. But technically, I think it's important to extend that sanction or that penalty to support personnel if evidence is available. Because that's conspiring. If a coach says that, "Arey, koi baat nahi, it's okay, kha lijiye supplement," it doesn't matter, knowing very well that supplement is not correct, then why should not the coach be dragged into the same net? I mean, logically speaking, that's what it should be working. But clearly, there's a hierarchical system. The athlete is much more vulnerable in the process, and therefore, or for example, trafficking. Apparently, I remember there was some case I read in the papers there where one athlete's friend was found trafficking a prohibited substance in Delhi, and was apparently used to be always there and used to give some substance. And athletes were taking it because they didn't know, and he was part of the trusted ecosystem. You see, so where does that trust finish? Where does the athlete draw the line to say that, listen, oh, you're a familiar face, I have tea with you every day, but if you're giving me the supplement, I'm not going to take it till I check. So that we have to achieve that ideal. We have to achieve that ideal to say that, listen, every athlete should be so careful Now, I know it's a tedious process. Any athlete who might be listening and saying, "Arey, to practically to ho hi nahi sakta, possible, we are competing, we are doing that." But at least we must have an ideal to go towards. We can't say that it doesn't matter. Chalta hai, it doesn't work, because you'll be sanctioned for 4 years, and 4 years in an athlete's life is complete death.
No, definitely.
All you have is a 4 years performance.
Yeah. I think, again, like I am surprised that more support personnel and coaches aren't getting, aren't coming under the net of this, because there is obviously a code, there is a law. Because
performance-based, Suheil. So there's an economic element to it. There's a performance-based element to it, because you win, you get money. There's also the job element to it, because a lot of the good athletes are actually with, employed with PSUs or banks or whatever. So that's also, they get very scared. In fact, a lot of them come and say, my first concern is, okay, I'll provisionally suspend it, but my first concern, what will happen to my job?
Yeah.
Oh, that's also a reality. So, and let's just explain the concept of strict liability, Suheil, here.
Yes.
That's the heart of a anti-doping situation. Strict liability means that the process, it's not about NADA to prove that you did it intentionally or did not do it intentionally. The mere presence of a system makes you liable. You can only avoid the consequences of that. So the strict liability is a concept which you will find in Article 3.1. Also, the concept of burden of proof, for all the lawyers who might be online, the concept of burden of proof is very interesting. When NADA has to establish something, it has to do what is called a comfortable satisfaction. Whereas if the athlete has to establish something, it's on balance of probability. Now, very quickly, not to bore the non-lawyers here, but there are usually three levels of burden of proof. One is the beyond reasonable doubt, which is used in criminal law. And a balance of probability is used in civil law. Somewhere in between is called comfortable satisfaction. So here we are looking at different thresholds of burden of proof to overcome. Yeah. So I just wanted to put that as a flag for whoever is interested.
No, I think very, very interesting. And the strict liability clause is obviously at the heart of, anti-doping. I'm wary of the time, so I'm just gonna move it forward. And I think you'll touch upon the strict liability in the next section. So I mean, as you've been through, a national level athlete, for example, in weightlifting, tests positive for a banned substance at a national competition. So what happens thereafter? Obviously, there is a procedure, there is a disciplinary procedure. So if you could shed a bit more light on, what happens thereafter, what is the role of the athletes? What is the role of, a lawyer or a legal team supporting that athlete?
Okay, so we typically, when we receive an athlete, as I said, we interrogate the athlete and find out, which side of the cheating line he or she is on. We typically try not to defend cheats because a lot of matters, majority of the matters we did pro bono. This was my own initiative, and we don't want to spend time on somebody who's cheating. But anyway, we usually find that people have come because they have a defense of an inadvertent case. Now, that inadvertence happens from what? One is you've taken a contaminated supplement. So we have to ask them what all you have taken in the last 3 months, 2 months. Do you have the bottles? Okay, please get them. There was a case where we had a female athlete which was found to be using a particular cosmetic, which could have been a potential source of an MHA. That's a famous case. So we have to ask that, because you have to first identify the source of where it comes from. Once you identify the source, now there's a difficulty in identification of the source, and that's a very, very critical problem. If I have a supplement, which I've been having, which is a standard supplement, how do I get it tested to see whether it's contaminated? Now, the point is there's no private laboratory in India which is acceptable to the NADA process to say that, listen, I went there, I got a check for a reasonable price, and it is actually contaminated. You have a lot of laboratories abroad. We have found that is a huge barrier to defense. I can't send it to Europe, incur a cost of many thousands and lakhs to get something tested. We don't have that ecosystem here where laboratories will, and often you tell them that, listen, can you test a laboratory? And they say, well, we are not going to take any liability for this. So that's a big issue. How do I establish that, yes, this is the source? Yes. Now, when we move on from that, now assuming you have established what's the source, then you have to prepare and find out that how did that source come to you and whether the athlete was negligent or not. There are two major defenses for reducing sanctions. Is 10.4 and 10.5 of the code, which is no fault, no negligence is 10.4, and no significant fault, no negligence in 10.5. The levels are different. Interestingly, if you look at the explanation given in 10.4, it will also say that even if you are taking a contaminated supplement, you ought to be aware that it is contaminated. Or if the medical doctor is giving something to you, you as an athlete need to be aware what the doctor is giving to you. So there have been cases, for example, where the federation's authorized doctor has prescribed a medicine which was found to have the source for that prohibited substance. There was one matter where fortunately the doctor was so honest, he said that I've committed a mistake and I gave an affidavit. And fortunately on the basis of that, we got the reprieve for the athlete. But how many doctors would do that and risk their job? So there are issues of that nature. Once we establish, then it's a question of process. There are certain NADA, there's what is called an anti-doping disciplinary panel before which you argue. And then you get an order against which you can appeal in India to what is called an anti-doping appeal panel. And if you don't agree with that decision, you go to CAS, which is the Court of Arbitration of Sport in Lausanne. And time permitting, I quickly I want to tell you about that problem. So one problem is legal assistance, proper legal assistance. Two is, there's an economic issue with most of the athletes. They're not very high-class legal assistance. So therefore, that ecosystem also needs to develop. Cadres need to develop who can help athletes at least establish their legal right, if nothing else. The other thing is, as I mentioned, the role of federations. Federations completely are no-touch policy on thing. I don't see why federations can't have counselors. I know it's a very idealistic thing, but federations can possibly have counselors, or we can have a counseling mechanism prior to the legal defense. Where the athlete goes to a counselor and says, this is what happened, what are my rights, what is there, without actually going through a very expensive legal process. Yeah, that's another suggestion I'm throwing out. And third is the inability to access CAS. You see, if we have had situations where athletes have won on two levels in India, WADA has taken it up in appeal in CAS. When it goes to CAS, it becomes an arbitration because it's an arbitral body. The arbitral body asks the athlete to deposit money, which could be many francs, thousands of francs. And then you're saying, like, listen, I won. Why should I deposit money? Then you end up asking for legal aid from CAS, and there's a long process where that is established. And if you lose at CAS level, then all the costs come to the athlete. So it's a very, for an Indian athlete, which is not economically so sound, it's a very, very, very difficult process to defend yourself all the way through. And because there's lack of time, I'm just quickly running through these points. Also, the accessibility of CAS. CAS is in Switzerland. You know, I mean, they do have video conferencing and all that, but in terms of establishing a proper defense before possibly a European arbitrator, which you should, people who are interested should read a study done by Rustam Setna on the skew of arbitrators from regions in CAS. And there's a lot of comment about that, that a lot of more Europeans, there are less Asians. Asian arbitrators also don't get enough arbitrations to deal with. So there's also that disparity, the north-south disparity, which is there, which we have spoken about in international conferences. So there's also this study also which you'll find by Sean Starr, who did this brilliant study of how case law developing in NADA has panned out over a period of time. Yeah. So there's lots of issues. There are issues about delays at the NADA level, at the disciplinary process level. It's taken sometimes a year or more for decisions to come, which means that if the athlete is ultimately pronounced as innocent at the end of a year or 2 years, I mean, you already lost 2 years in suspension. Because the moment you get a notification of a positive thing, you are actually suspended, provisionally suspended at the time. So these are processual issues, if I may say, which affect ultimately, the right and livelihood of an athlete. And if we need to, I think we should, I've been talking about it forever, but I think we need to address these pinch points in a much more constructive manner.
Thank you, Anish. And interesting. We could go on for a while longer. Thank you for putting it very briefly. I think as we're reaching close to 6 o'clock, what we can do now is take some questions. So in the chat, there are a couple of interesting questions from Anish Gopi, which I'll just read out to you. I think the first one you have answered to a certain extent, but you might want to add to it. So the first question is, I'll just read it out for everyone. What is your view against the globalization of anti-doping norms, given that you have noted there are various socioeconomic factors that may push an athlete to dope? And the second one is, do you believe NADA's rules with regard to disciplinary hearings are constitutionally valid, keeping in mind that NADA appoints the members of the panel while also presenting the case against athletes? Seems to be a clear violation of the principle of natural justice.
Okay, to my namesake Anish, good question. Globalization first. See, the whole sports legal system works, and the sports governance system works in a pyramid. And the whole principle of the sports system is that it is autonomous. It's
Sonali,
away.
उसमें कच्चा प्याज, टमाटर,
Somebody needs to mute.
ऐसा डाल के ऊपर से ये किया तो भी अच्छा लगेगा.
Vani, can I please ask you to mute?
Yeah. Okay. So that was reality intervening. So good to have that from all the serious talk. And now I'm feeling hungry. The thing is that, Anish, the thing is that I think it'll be very difficult to walk out of that system, because the Olympic movement is based on that system. Okay. The only way is to ensure advocacy from India at that international level. More and more people who are stakeholders should speak up and say these are our problems. Okay, when we have done so in some international conferences, and people have actually come on the sidelines and said, we didn't realize that there are so many problems. I said, well, you are in your own world in Western Europe and all that, where sports is dominated. The governance of sports is actually focused in Switzerland and all the areas, that you are not taking note of our cultural problems. So advocacy is very important. We may not be able to legally come out of that system. Secondly, on constitutional validity, it has been explored that whether a natural justice right is being violated. I don't want to present a full view because I think it's a detailed discussion. But the fact that you do, even amongst the rules of NADA, there's a right to fair hearing under Article 8, which you get. And you have a right in the system to take that point up to the appeal panel or to the CAS panel. The fact that the NADA is actually the testing authority and the secretarial authority and the prosecutor in some ways is a problem. Solutions are not ready for tackling that. Maybe there have been suggestions that the anti-doping agency should actually be completely autonomous and sitting outside NADA, right? So, but these are matters of probably more offline discussions.
Thanks, Anish. Yeah, I would like to invite anyone else who might have a question. I think we can take another 5-10 minutes. Um, I mean, anyone who has a question can raise their hand or put it in the chat. Um, Great. We have another question coming in from Apu Chandra. So I'll just read it out again. Are samples for anti-doping tests always taken with informed consent of the athlete? And have there been instances where samples were collected and analyzed for any purposes other than what was mentioned as purpose for testing, such as gender testing? How far is this a problem in India?
Okay, so I don't know of anything specific on that, but typically when the DCO approaches a athlete for testing, it is in the NADA framework. Whether that sample is utilized for other purposes, I don't think it should be happening, because there's a certain privacy of that biological sample as well, right? Which the NADA system or the NDTL system ought to protect. So it should not be typically used for anything else. You've got a point there, but I don't know of any specific case where it might have happened. See, of course, if there's a gender testing happening, as it has happened in a lot of the cases, there's all the cases that we have discussed, Dati and Simania and stuff like that. So that's a different issue. That's probably a purposive testing for the purpose of determining what WADA has been talking on gender.
Thanks, Anish. We have two hands up for questions. As Rustam put his hand up first, can I ask you to unmute yourself and ask the question?
Sure, thank you. Thanks, Anish. Just a very quick one. I was just wondering what your thoughts were on NADA establishing some sort of pro bono list, so similar to what the CAS and FIFA have, so a pro bono list of lawyers that athletes are actually made aware of when they are charged. So when they receive that first charge of them having committed their ADRV, anti-doping rule violation, they are made aware of the fact that they have access to decent legal representation at no cost. And what sort of hurdles do you see in actually establishing something like that? Because there seems that something like this is also could attract a lot of interest from young lawyers as well, who are looking to get experience in the field, while at the same time actually making a difference to the career of an athlete. Thank you.
Thanks, Rustam. First of all, congratulations for a brilliant paper, which I have shared reference to. And
thank you.
Continue to do your good work. No, see, let me take a parallel. For any court in the country, there is a legal aid cell, and there's a legal aid provision, which is quite expansive at every court, high court level. And I think there's no reason why there can't be a legal aid cell, which is manned by young lawyers who are willing to provide their time for helping athletes. In fact, I think a two-step procedure could be available easily at not a huge cost to the administration. One is, of course, counseling, as I've said. You can have a counseling process, which is there, which is a pre-legal process. And then you could have the legal aid process. So I don't see any difficulty in establishing something like that. The point is that the establishment, the NADA establishment does not need to think that by establishing that you're actually helping cheating athletes. That's not the point. Sometimes I think there's this conflict. These are, out of the 10 athletes, how do you know? 7 might be inadvertent and they need to have their rights. There's no reason why everybody needs to be painted with the same color. So if young lawyers are willing to provide the time, absolutely. And I think if NADA doesn't do it, I'm sure at some foundational level it can be done.
Yeah, definitely. If there's a way that this can be done even privately, it's something I am certainly quite passionate about If there is interest from people on this call, I mean, and we can sort of figure out a way to take this forward and to the powers that be, I guess.
Yes, and these suggestions can go out to the organizers as well. I mean, all the foundational work can help in really making a panel of lawyers and making it available. No difficulty.
Great suggestion. I think, I think, and the Sports Law and Policy Network can maybe spearhead that along with other stakeholders. I know there's a lot of interest, from grassroots organizations to foundations to even private players, so definitely.
Well, it's quite surprising the amount of interest young lawyers have in sports law. And I'm quite, it's pleasantly surprised. And that's because of the context and sports context. And so I would say that if somebody actually structures it and lets out a call, I'm sure there'll be lots of good, competent youngsters who will be willing to offer their advice.
Definitely. Before I move to the next question, that Tarun has his hand raised up, Nandan has made an interesting comment, which is in reply to Apu Chandra's question, or it adds context. Nandan says the 2021 World Anti-Doping Code specifies that samples taken from athletes for anti-doping tests can also be used for gender verification purposes. Okay. So that's an interesting update to the anti-doping code. So I guess they are free to do that. So Tarun, please go ahead, unmute yourself and please ask your question.
Thank you for the session. Firstly, my question is around how the esports is emerging in throughout the world right now. So I'm just trying to understand how doping as a regulation might change for esports specifically, because the NADA list might not be applicable in Toto for like esports, right? Something like which can amplify physical strength might not apply directly to esports. So how does the entire framework in that sense change? For example, if I'm practicing something which might help me in a different form athleticism, how will that affect me if I have to like engage in esports? So if I'm not even in sport for anything which I'm taking like physical, for example, I'm working out something like that, how will that impact my esport? So if I am practicing per se, so I just want to understand how the entire thing changes. Thank you.
So Tarun, I must confess, I haven't taken a deep dive into esport jurisprudence, so to say. It's still developing. It's very new. My guess would be that the fact that it is, I mean, if I take it logically, esports is obviously here to stay. It's becoming big. It involves a lot of youngsters. I have heard of reports of various substances being used and in fact advertised also for your mental strength and stamina in order to achieve better results in esports. And there's a lot of discussion in the West around this. So I think I'm not aware of every particular aspect, but it's worth I think it will obviously come in. There's no question about it, because the moment you formalize the NADA process is under purely from a regulatory perspective is under the Olympic system. So the moment esports gets organized and governed in an international system, some form, some mutation of the code is going to be applicable to that as well. I don't see it not happening because the stakes involved are very high. The moment you have money stakes involved, everything is going to go.
All right. Thank you so much.
So I think we'll leave it at that because we've already gone 10 minutes beyond our time. Vani, I'll hand it back to you.
Thank you, Anish and Suheil, for taking your time off for this session. It was a very insightful discussion, and thank you to all our viewers for joining us this evening. So this brings us to the end of the second session of Sports Law 101, and we look forward to hosting you all soon again. Thank you.